Yeah. So in this revision series, let's continue the LLP Act 2008. Okay. We are done with partnership already. And here we are going to deal with the LLP. Okay. So in LLP, we have in total 81 sections and four schedules. We are going to see all the four schedules. Okay. And please try to see the intro part, whichever is given in your material. That is nothing but the dates. Everything is quite important. Ma. Why? Because we have to concentrate for objective two, right? Those dates, when it got into force, when it got implemented, schedules, etc., etc. Please make a note of it. Okay. Just give a good reading before you go for exam. And LLP Act 2008. So let's begin with this. As you know, LLP is one of the hybrid nature of business organization where we have certain features of the partnership and we also have the certain features of the Companies Act 2013. Okay. See, who will administer LLP is Ministry of Corporate Affairs and ROC, Register of Companies. Okay, so whatever communication you want to do, you have to do it to the ROC. Same like in Companies Act 2013. How do you do? In the same way. Okay, and Indian Partnership Act is nowhere applicable for the LLPs and all. Limited liability partnership, where we have partners, but partners' liability is limited to the extent of their capital contribution. Okay, and please make note that there are features of this LLP is nothing but like it's a body corporate, it has separate legal entity, it has perpetual succession. Okay, the mutual agency is only to certain extent. So there are features also. Once you just give a good rating, I don't think features will be a kind of important question. Maybe just give a good rating. Okay, you can understand that already. And that's it, ma, about LLP introduction and all. Let's get into the main topic. First one is about partners. Okay. So in section 5, they have defined about the partners. Who can become the partner of the LLP? Okay. So an individual can become the partner of the LLP and a body corporate also can become the partner of the LLP. So individual cannot become the partner of the LLP if he is unsound mind person. Okay. And if he is an insolvent person. And if at all he applied to be adjudicated. Okay. And his application is still pending. So adjudicated insolvent also is not eligible to become an individual, to become a partner of an LLP. Okay. So how many minimum number of section 6 will define you? How many minimum number of partners do we require? How many minimum we require? 2 partners here. Okay. At least 2 partners, out of which one must be for sure resident of India. Moreover, to become a, sorry, not section 6, it was in section 7. Let me just erase all these things. Yes. Yeah. So section 5, section 6, section 7. Section 6 will teach you about the partners. How many minimum partners we require is 2. Okay. Section 7 teaches you about the designated partners. So designated partners are the people who takes the responsibility of the compliances and etc. Okay. So in companies, of course, we have to do compliances. We will appoint a few people as an in charge for compliances. Am I correct? Right. In the same way, in LLPs also, we need, there is a need of doing compliances, few of the compliances. It is not that much difficult in case of like you do in a company. Of course, less compliances done. But then also we require few people who takes that responsibility. For that reason, we will appoint designated partners. So how many designated partners we require to incorporate an LLP? At least 2. Out of which one must be resident of India. Remember this? We require how many designated partners, ma'am? To incorporate LLP, at least 2. So without designated partners, can you incorporate LLP? Answer is no. How many you require? At least 2. So out of which one must be mandatorily a person who is resident in India. who is resident in India? A person who stayed in India for at least like 120 days in a financial year. Okay. Previously, we used to understand as if it is like 182 days, but they have changed this. Remember this point also, 120 days. Okay. And whenever you appoint a designated partner, okay, we require certain things from him. One is we require his consent to act as a partner. Okay. In form number 9. And after that, we require his particulars in form number 4. And we have to file all his details to the registrar in form number 2. Okay, so these all things are required to appoint a designated partner. And who will be disqualified to act as a designated partner? Disqualifications. Who is disqualified? Same. An insolvent is disqualified. Okay. An insolvent person is disqualified within like preceding 5 years. If at all you were insolvent, then you are disqualified to act as a designated partner. Okay. So within previous 5 years. And the next one is you got suspended. Why? Because you made a defaulting payment to the creditors. Same, 5 years. Before 5 years, what happened? You got suspended because you didn't pay the money which you have to pay to the creditors, or you made a defaulting payment to the creditors. So you are disqualified and you are a convicted person. And moreover, imprisonment has been imposed on you, which is less than 6 months. So in that case also, you are disqualified, imprisoned for not less than 6 months. So you are disqualified to act as a designated partner. Okay. So till here it is about designated partner. And next concept is about section 11, incorporation of LLP. Okay. So to incorporate incorporation of LLP, there are 3 steps which we have to follow to incorporate an LLP. One is step 1, reserve a name, reservation of name for an LLP. See, first step what we have to do, we have to reserve the name for the LLP. Okay. And next step is submit incorporation documents. Submit incorporation documents with registrar. So after reserving a name for your LLP, submit an incorporation document. And step 3 is nothing but registration. Okay. So we will see each step. So how to reserve a name of an LLP? There are certain conditions which you have to follow, like while you are reserving the name of the LLP, make sure that you have to follow name rules which has been given by the central government. And you can pick at least 6 names. Out of that, 1 name will be allotted to you, and that name will be reserved for at least like 3 months. These are general details which I have already read in Companies Act also, right? And after that, what you have to do, step 2, we will directly go for step 2. Okay. So in step 2, I told you that you have to submit an incorporation document with the registrar. No. So that incorporation document will have all the details of the LLP. And if at all you have given false details in that incorporation document, then you will be imprisoned for 2 years and fine will be imposed on you, which is like minimum 10,000 rupees, which may extend to 5 lakh rupees. Okay. So you have to remember this imprisonment details also. Sometimes we can expect a question. As you know, objective is also our priority. Please make sure to understand this. Okay. So step 2 is nothing but details of incorporation you have to give. If at all you give false information, you will be imprisoned and fine will be imposed on you. Okay. And next concept is about how do you change of registered office. Okay. So if at all you want to change the address of your registered office, how do you change? There is a procedure which you have to follow. First of all, you require consent of all the partners. Okay. And next, you require consent from the secured creditors. If at all you are changing it from one state to the another state. If there is a change from one state to the another state, okay, then in that case, we require, along with the consent of all the partners, secured creditors' consent is also required. Okay. See, whatever you made the change of that registered office, you file a form to the registrar. Okay. In which form? Of form number 15. And make sure to publish it in newspapers at least 21 days before you file notice with the registrar. Okay. So these things you have to do. This is a procedure you have to follow whenever there is a change of registration office from one state to the another state. If at all you want to change the registered office from one jurisdiction to the another jurisdiction of the ROC, same procedure is required. Okay. No change, same procedure. Next concept is about conversions. Okay. So if at all you want to convert your firm into LLP or a private company into LLP or a public company into LLP. So first schedule, we have 4 schedules now. The first schedule refers to the rights and duties of the partners. Your second schedule refers to conversion of firm to LLP. Okay. See, remember only one conversion. It is applicable to all the conversions here. Okay. If you remember the procedure of one conversion, same thing we will repeat in another conversion. Okay. So make sure to concentrate only on this. So when you're converting a firm to LLP, there are conditions you have to follow. Okay. What are those conditions? The first condition is whoever are the partners of your firm. Okay. Partners of firm will act as will act as partners of LLP. That is first condition. Okay. And second one is partners are bound to apply provisions whichever are given under second schedule. So these 2 conditions you have to follow. Next, what is the procedure? Procedure is very simple. First of all, you have to file a statement. Okay. You have to file a statement by the partners in form number 17. Okay. So what does this statement contain? It contains certain particulars. What particulars? Like name or registration number of your firm and the date on which your firm got registered as per Indian Partnership Act. Okay. So these all details will be present in that statement. And second, please submit incorporation document and statement. Same like how do you incorporate your LLP? That thing. Okay. So after that, what registrar will do? Registrar, after verifying it, he will issue certificate of incorporation in form number 19. Okay. So after getting form number 19, LLP, what it must do? It must within 15 days. Okay. Within 15 days, it has to inform it to the ROF. Because your firm got converted into LLP, no, we have to give communication to the ROF also, right? You have to give communication to the ROF that your conversion, regarding your conversion and regarding your particulars, you have to give information to this ROF. Done? So this is the conversions concept. When you're converting firm into LLP. Now, what if you're converting private company into LLP? Okay, I'll make very little changes here. You just see here what it is like third schedule. Yes. What schedule is it? Is third schedule. Okay. Here we will refer private company. So conversion of private company into LLP. and. So two conditions must be satisfied. Procedure is one and the same. So what are those two conditions here? Same. Okay. But I'll just change the subject. Yes. What are the two conditions we require? The shareholders, whoever are acting in that private company, will act as partners of the LLP. That is your first condition. Is that clear? Okay. The second condition is no security interest will be given on the assets of the company. Okay, no security interest. So these two conditions must be followed. What is the procedure saying? Statement will be given by whom? Statement will be given by the shareholders. Okay. So your statement will be given by the shareholders. So what will be present in that? The particulars, the name, the registration number of your company, on which date your company got registered, all these details will be present. And along with that, one incorporation document and statement. You will give it to the registrar. Registrar, after verifying it, he will issue certificate of incorporation, which is in form number 19. Okay. And after that, within 15 days, you will inform to the ROC, because your private company got converted. No? So you have to inform to the ROC about your conversion and details of your LLP. That's it. Okay. So what if you're converting public company to LLP? Same thing, no difference. Okay. But the difference here is, instead of third schedule, you have to write it as a fourth schedule. Here, private company instead of a public company. And anymore, nothing. Okay. Yeah. So what is the schedule, ma? Fourth schedule, conversion of public company into LLP. Same, shareholders of this company treated as partners of the LLP, no security interest. Procedure, same statement, form number 70, incorporation document, registrar ratio, form number 19. Within 15 days, please inform to the ROC. Okay, that's it about the conversions. And the next concept is about dissolution. Okay, so when do you dissolve your company? Sorry, LLP, dissolution and winding up of your LLP. Okay, so there are two modes of dissolution now. One is voluntary dissolution. So voluntarily you can dissolve it, or eitherwise by tribunal. So tribunal will order you to dissolve. So when tribunal will order you to dissolve, there are certain cases. See, what if even after the expiry of these 6 months, you didn't appoint any partner and you alone doing the business. So in that case, of course, the tribunal will ask you to dissolve your LLP. And the next one is when you are unable to pay the debts. Okay, unable to pay debts. As you are incurring losses, you couldn't able to pay the debt. So there is no scope of doing business. Tribunal will order you to wind up or dissolve. And what if you are doing business against public policy, against interest of sovereignty, against integrity of the India, then in that case also. Next one is, what if you made a default in filing financial statements? Default in filing financial statements, statement of account and insolvency for around like 5 years, 5 consecutive years. Okay, if at all you made a default continuously for 5 years, you're not even filing any statement of account and solvency, then in that case, tribunal will order you to wind up. And last one is just and equitable ground. Just and equitable ground is nothing but tribunal will ensure that it is well enough to just dissolve this particular firm. That was the ground which will be issued by the tribunal. So in all these cases, by tribunal's order, you have to wind up your LLP. So this is the end of the LLP. In the next next topic, we will start NI Act. Okay, ma'am?